changes to amended laws concerning rent overcharge complaints.
Okay. There are a lot of changes concerning rent overcharge complaints. The first thing is that instead of having what has been called the 4-year rule or the 4-year look-back period or the 4-year statute of limitations, it's now been increased to 6 years. And what that means is that if a tenant filed a complaint with DHCR today or raised a claim in a court proceeding today that they have been rent overcharged, the DHCR looks at first, what is the base date rent for looking at this complaint? So if it's August 2019, 6 years back is August 2013. If it was 4 years, it would be August 2015. So going back another 2 years allows for more review of, you're not looking at what was the rent 4 years ago and has it been legally increased. You're looking at what was the rent 6 years ago and has it been legally increased. So that's a big change. And in addition, there's a lot of language in the new law saying that if the DHCR or a court needs to look at information that goes back more than 6 years to figure out what really should be the legal rent, they can do that. So in effect, there is no limitation on how far you can look back. There's a limitation. If there is an overcharge, the overcharge and the refund can't go back more than 6 years. But the DHCR or court may seek information going back more than that period of time to determine if there is an overcharge.
And they can do this to pending complaints as well as newly filed complaints?
Yeah, that will probably be a point that will raise a lot of objections, and it remains to be seen where they'll go. One of the things that both tenants and owners have been concerned about for a while now is that DHCR has been backlogged to the point where there have been a lot of rent overcharge complaints filed in the last few years. And I know in my office, for example, there are complaints that we have answered on behalf of owners a year ago, a year and a half ago, 2 years ago even, and there has been no ruling by DHCR on these complaints. So when the complaints were answered a while ago, the 4-year statute of limitations applied. So in a sample case, an owner or their attorney would file lease documents going back 4 years, and in some cases you may say, okay, here's our lease documents, there's no rent overcharge. Or you might say, here's our lease documents, we see that there is some overcharge in reviewing this, and we are now giving the tenant a refund and reducing the rent, so there's no further problem with this. So now that those complaints have sat all this time, DHCR has now started sending out, within 2 weeks after the law changed, DHCR on the pending overcharge complaints is sending out notices saying, in connection with this proceeding, the law has now been changed, there's now a 6-year period to look back, send us documentation going back between the 4 and the 6 years. And in some instances, that may not change the result. In some instances, it may change whether there is an overcharge, depending on what's happened, between 4 and 6 years ago. And it may also now involve further delay of making a decision because the DHCR has to give the owner some time to respond to this. And one of the things owners may want to do who are responding to these complaints is it probably is prudent to provide the information if you have it. Otherwise, DHCR will make a decision based on a default method. But what owners may also want to do is make objection to the change in the procedure. Even though the law specifically said it's applying to pending proceedings, changing the rules at this point in the game, after people have answered complaints a long time ago, can create liability that wasn't there otherwise. So is that fair? Is that a violation of due process? Is that a taking of property, either physically or in a regulatory manner that violates the Constitution? Those types of objections should be raised. Where they will go remains to be seen, but in order to preserve the right to appeal if there's a bad result, it would be helpful for owners to make those objections.